like lawyers. I've spent 35 years working alongside them, managing their books, sitting in their partner meetings, and occasionally telling them things about their own finances they didn't want to hear. So I say this with genuine care. Most law firms are paying their people to do the exact opposite of what the firm needs them to do. And then everyone wonders why nothing changes. Let me show you what I mean. A law firm brings in a consultant to build a succession plan, a roadmap for how the firm will handle it when senior partners retire and their clients need to land somewhere safe. Good meetings happen, timelines get drawn, successor candidates are identified. Everyone leaves feeling like responsible adults. 6 months later, nothing has moved. The senior partner, who was supposed to start introducing clients to her successor, hasn't done it. The younger attorney tapped to take over key accounts is still waiting for an invitation to the table. And the managing partner is frustrated because the plan looks so clear on paper. It was clear on paper, but nobody looked at the compensation plan. Here's something I've learned the hard way. The partner compensation plan is the most honest document in any law firm. It doesn't care what the strategic plan says or what the managing partner promised at the retreat. It tells every partner, every day, what the firm actually rewards by putting dollars behind it. And in most firms, the partner compensation plan rewards the opposite of what succession requires. Succession needs senior partners to share client relationships, but the comp plan rewards holding those relationships tightly because your pay is tied to the revenue you personally control. Succession needs partners to spend real time mentoring younger attorneys, but the comp plan counts billable hours and business generation, and mentoring doesn't show up in either column. The succession plan didn't stall because people didn't care. It lost to the comp plan, and it was always going to. Which leads us to the origination credit trap. If you don't deal with origination credit in your daily work, here's what it means. It's the way most firms track who brought in a client. The partner who landed the client gets credit, and a chunk of their compensation is tied to it for as long as that client stays with the firm. In theory, that's fair. In practice, it creates a problem that quietly undermines everything else the firm is trying to build. Picture a senior partner who originated a client 15 years ago. Every matter that client generates still flows through that partner's credit number. The partner may not have done substantive work for that client in years, but the credit and the paycheck attached to it stay with them. There is no financial incentive to hand that relationship to a younger attorney. Now tell that partner the succession plan needs them to transition that client. From their perspective, you're asking them to take a pay cut. Partners, like all of us, are rational about their income. The fix is not complicated. Origination credit rules need to reward transferring client relationships, not just creating them. Shared credit during a transition, sunset provisions that gradually shift credit to the working attorney, and bonuses tied to successful handoffs. The mechanics vary, but the principle is the same. If you want partners to move clients along, make it financially smart for them to do so. There's a harder version of this problem, and it's the one that does the most long-term damage. In firms where multiple partners share ownership, often called an equity partnership, each partner's compensation comes from a shared profit pool. The size of your slice depends on what you contribute. But here's what happens over time. Some partners' contributions decline. Not because they're bad people or bad lawyers. Production peaks, practices shift, health changes. The partner who was a top producer at 50 may be well below the expected contribution level at 62. Most firms respond by doing nothing because nobody wants to have the conversation. The cost of that silence gets spread across every other partner. High performers carry the biggest burden by effectively subsidizing colleagues who no longer carry equivalent weight. And the next generation is watching too. The senior associates and junior partners your firm is supposedly grooming for leadership see a system where declining production carries no consequences and tenure looks like a lifetime appointment. That does nothing to build a succession pipeline. It inspires people to update their resumes. And so we have to talk about de-equitization, which sounds scary, but it doesn't have to be. De-equitization simply means transitioning a partner from an ownership role in the firm to a non-ownership position. Typically, it's an income partner, senior counsel, or of counsel. Instead of sharing in firm profits and risk, the partner receives a defined salary. Most managing partners flinch at the word because it sounds like a demotion. It doesn't have to be. Think about the senior partner who no longer wants the pressure of ownership-level production expectations but still has valuable client relationships and decades of institutional knowledge. A well-designed transition gives them a role that fits where they actually are: a guaranteed salary, a manageable workload, a respected title, and continued benefits. For many partners in that situation, that's not a demotion, it's a relief. The critical part is that the framework has to exist before you need it. Written criteria adopted by the partnership and applied consistently. Thresholds defined when no specific partner is in the crosshairs. A grace provision for health or personal circumstances. And a real path back to equity for partners who rebuild their practice. When those structures are in place ahead of time, the conversation changes completely. It stops being, "we're pushing you out," and becomes, "here's an arrangement that works better for everyone, including you." So let's look at 3 things worth doing over the next 3 months. First, put your partner compensation plan and your succession plan side by side. Ask one honest question. Does the comp plan reward or punish the behaviors succession requires? If a partner loses income by transitioning a client, you've found your problem. Bring in an outside facilitator or consultant to help you solve it. Second, define in writing what equity partnership requires before you need to, not when you're evaluating a specific partner. Now, when the conversation can be about principles rather than people. Include contribution expectations, recognize non-billable value like mentoring and leadership, and assess trends over multiple years so nobody's reacting to one rough stretch. Third, build a non-equity partnership role worth having. If the only alternative to full partnership is the exit door, every transition conversation will feel like a firing. Design a senior counsel or income partner position with real compensation, real standing, and real purpose. That role's mere existence changes the dynamics of every succession conversation your firm will ever have.